The fluorescent lights in the hearing room buzzed with that particular hum that always makes the air feel thinner than it should. I walked in carrying a single accordion folder, my heels quiet against the linoleum, and the first thing I noticed was that my brother was already seated at the opposite table. He had dressed well. Dark blazer, tie pressed flat, the kind of effort he never made for anything that didn't benefit him. His wife sat beside him, shoulders back, hands folded, performing composure the way she always performed everything, as though the cameras were already rolling. They had arrived early to claim territory. I took my seat without looking at them. My attorney leaned close and whispered that the hearing officer would be in shortly, that we should stay calm, that the evidence spoke for itself. I had said those same words to clients in deposition rooms dozens of times. I knew what they meant and what they didn't mean. Evidence never spoke. People had to speak for it. The door to the side panel opened, and the hearing officer walked in. A man in his early 60s with silver at his temples and reading glasses tucked into his breast pocket. He carried a thin stack of folders and set them down without ceremony, the way someone does when they have done a job for so long that the ritual no longer requires performance. He sat, pulled out his glasses, and looked down at his intake sheet. Then he looked up. He looked directly at me, and he stopped. It was subtle. A beat, maybe two. His hand rested flat on the folder. His eyes held mine just a half-second longer than a stranger's would. Something moved across his face, not shock exactly, but recognition, the kind that arrives unexpectedly and takes a moment to land. He blinked, adjusted his glasses, and cleared his throat with the quiet efficiency of a man regaining composure. My brother hadn't noticed. He was scanning the room, cataloging who was watching. His wife was whispering something to their attorney, who was already sorting papers with practiced speed. Neither of them had seen it, but I had. I kept my expression neutral and set my folder on the table. My hands were steady. Whatever that moment meant, I wasn't going to be the one who showed cards first. The session opened with procedural language, the case number, the names, the nature of the dispute. My father had died 7 months earlier, leaving his house, his savings, and a small commercial property to me. The will had been updated 14 months before his death, signed in the presence of 2 witnesses and a notary, and filed properly. My brother was contesting it on the grounds of undue influence, claiming that I had manipulated our father during the last 2 years of his life when his health was declining. It was the kind of accusation that was difficult to disprove because it targeted something invisible, a relationship, a dynamic, the interior of a house no one else had seen clearly. My brother's attorney was good. He moved through his opening statement with the measured confidence of someone who knew exactly how this kind of case worked. He used words like isolated and dependent and susceptible. He talked about my father's medication, his reduced mobility, his increasing reliance on the one child who had moved back nearby. He never once mentioned the 11 years during which my brother had lived 40 minutes away and visited for holidays only when it was convenient. I sat and listened. I had trained myself to listen the way I listened to financial records, not for what was said but for the structure underneath, the choices made, the things left out. When it was our turn, my attorney laid out the basics. The will had been prepared by an estate attorney my father had used for 20 years. The updated language had been his explicit request. My father had been examined by his primary physician 6 weeks before the will was changed, and his cognition had been assessed as intact. All of this was on record. My brother's wife shifted in her chair. My brother kept his face still. The hearing officer said little. He made notes and asked procedural questions. But twice more during that first session, I caught him glancing at me in that particular way, like someone trying to place a face they have seen before in a different context. I didn't know yet what it meant. I didn't know whether it would help me or expose something I wasn't prepared for. What I knew was that my brother had planned this for longer than I had realized, and that the hearing room was only the current theater of a conflict that had been building for years. The drive home took me past the house. I didn't stop, but I slowed. My father had bought it in 1987. The front porch still had the same wooden swing he'd hung when I was 4. The hedges needed trimming, something he would have handled himself until about 3 years ago when his knees stopped cooperating. After that, I had handled it. I drove over on weekend mornings with coffee, and we would sit on that porch and talk about nothing important neighborhood gossip, old movies he liked, the way spring came later every year. My brother called maybe once a month, short conversations that ended with something vague about getting together soon. My father knew the difference. He never said so directly, but he knew. I kept driving. Back at my apartment, I opened my laptop and spread the documents across the kitchen table. I had been a forensic accountant for 6 years, first at a mid-size firm and then consulting. My job was to find things people hid inside: numbers, falsified entries, misattributed transactions, the small deliberate errors that looked like accidents until they didn't. I had testified in 9 cases. I had a reputation for being thorough in a way that made opposing attorneys uncomfortable. My brother had not considered that when he chose this fight. Or maybe he had, and he thought I was too close to the situation to see clearly. He was wrong about that. I pulled up the estate bank statements my attorney had subpoenaed. My father's primary account, the one linked to his mortgage and utilities, showed consistent outflows over an 18-month period. Transfers, modest in amount but regular in frequency, to an account I didn't recognize. I cross-referenced the account number against everything I had. It didn't match my father's known accounts. It didn't match mine. It didn't match any of the utility vendors or service providers. I made a note. I did not jump to conclusions. That was the discipline. You marked what you found and kept moving, and you let the pattern reveal itself. I worked until 2 a.m. The second session was 2 weeks later. My brother's side presented their witnesses. A former neighbor who said she had noticed I was at the house constantly and that my father had seemed quieter in his last year. A distant cousin who said my father had mentioned feeling confused about his finances. Both were vague, impressionistic, the kind of testimony that plants a seed of doubt without providing anything concrete. Their attorney was building an atmosphere, not a case. That was a deliberate strategy, and it told me something about what they actually had. During the lunch recess, I stepped outside into the parking lot to call my attorney. The spring air was thin and cold. I was halfway through explaining what I'd found in the bank statements when I heard footsteps behind me. I turned. My sister-in-law was standing a few feet away. She had her arms crossed, coat pulled tight, and the expression on her face was one I had seen many times, the specific look of someone who has decided that offense is easier than accountability. "He should have gotten half," she said. "He's the oldest. That's how it should work." I looked at her for a moment. I said, "That's not how wills work." She stepped closer. "You were always his favorite. You made sure of it. You pushed your brother out, made him feel unwelcome so your father would lean on you instead. And then you talked him into changing that will when he was too tired and too sick to think straight." I kept my voice even. My father was assessed as fully competent by his physician 6 weeks before he changed the will. That's documented. Your attorney has a copy. She shook her head like I had said something dismissive instead of factual. "You can hide behind paperwork all you want. We know what you did." I told her I needed to finish my call and turned back toward the building. Behind me, she said, loudly enough to be heard, "Don't think we don't have more." I noted that too. That evening, I called my attorney and told him about the transfers. He asked if I could trace the account. I told him I already had. The transfers had gone to an LLC registered in my brother's wife's maiden name. The LLC had been formed 3 years before my father died and had received a total of $42,000 from my father's account over 18 months. The transfers were never discussed with me. They never appeared in any accounting my brother had provided. My attorney was quiet for a long moment. Then he said, "This changes the case." I said, "I know." The next week, before the 3rd session, I did something I had been resisting. I drove to the house, let myself in with my key, and went through my father's desk. Not to remove anything, his estate was under probate, and I wouldn't touch the original documents, but to confirm what I already suspected. In the bottom drawer, inside a folder labeled Tax Keep, I found printed bank statements my father had annotated by hand. Beside each transfer, he had written a single question mark. He had noticed. He had written it down. He didn't know who the account belonged to, but he had known something was going wrong. I photographed every page with my phone and sent them to my attorney that night. What I felt standing in that room wasn't triumph. It was grief that had found its final shape. My father had spent his last years watching his savings drain out without understanding where they went, marking it with small penciled question marks in a folder no one else knew to look for. He had trusted the wrong person with access to his accounts, and the person he had trusted had used that access quietly and for years. My brother hadn't contested the will because he believed it was fraudulent. He had contested it to buy time and create confusion while hoping the financial transfers would stay buried. The 3rd session opened with our motion to introduce the bank records and the LLC documentation. My brother's attorney objected on procedural grounds. The hearing officer reviewed the motion quietly for several minutes. My brother sat rigid beside his attorney, a stillness that was different from composure. The hearing officer allowed the records. My brother's wife reached over and gripped his arm. He didn't look at her. When our financial expert took the floor and walked through the transfers, the room got the particular kind of quiet that happens when something undeniable is being stated plainly. $42,000. 18 months. An LLC registered to a company that had no business purpose, no employees, no website, no recorded activity other than receiving these transfers. The expert traced the money from that LLC to a renovation on my brother and sister-in-law's home. A new kitchen, new flooring throughout, a detached garage that had been converted into an office suite. My brother's attorney stood and said his client was not on trial here. The hearing officer said he was aware of the scope of the proceeding, but that the records were relevant to the question of who had actually exercised undue influence over the decedent. My brother said, quietly but audibly, "This is a setup." The hearing officer looked at him over the rim of his glasses and told him to address his comments to his attorney. In the break, I stood near the window in the hallway and watched the parking lot. My attorney was on his phone. On the other side of the building, I could hear my brother's raised voice, not words, just the pitch and frequency of a man running out of options and deciding that volume might compensate. The hearing officer stepped out of a side door for a moment, coffee cup in hand. He paused when he saw me. He walked over. He said, "Miss Calloway, you may not remember me. My name is Gerald Harmon. About 3 years ago, you testified as an expert witness in the Prescott fraud case. You were the forensic analyst who identified the layering pattern in the shell accounts." I remembered it. It had been a long engagement, 16 months of document review, and the scheme had been sophisticated. Multiple LLCs, small transfers designed to stay under reporting thresholds, a cleanup pattern that looked almost accidental. I said, "I remember." He said, "My brother-in-law had his retirement savings in one of the funds that scheme destroyed. He was 61. He had to go back to work." I watched that case very carefully. He looked at the folder in my hand, then back at my face. "I recognized the pattern in these records before your expert finished his third slide." He went back inside before I could respond. I stood there for a moment, with the cold morning air coming through the gaps in the window frame. I understood now what the look had meant that first morning. He hadn't been uncertain about me. He had been recalibrating, slotting the person in front of him into a case history he hadn't expected to see again in this kind of room. I also understood that it didn't change anything procedurally. He would rule on the evidence. What I had just given him was something else, context for what he was seeing, confirmation that the pattern wasn't coincidental. The final session was the shortest. My brother's attorney had filed a motion to exclude the LLC records on privacy grounds. The hearing officer denied it in 3 sentences. Then he allowed my brother to address the transfers directly. My brother sat forward and said that the money had been a series of personal loans from our father, agreed to verbally, and that our father had been happy to help him during a difficult financial period. The hearing officer asked if there was any documentation of these loan agreements. My brother's attorney said no written agreements had been located, but that verbal contracts were legally recognized. The hearing officer asked whether my father had ever indicated to anyone else that he had made these loans. There was no answer. He asked whether the transfers had been mentioned to the estate attorney or disclosed during the probate filing. My brother's attorney said they had not been included because their legal status was still being determined. The hearing officer set his pen down. He said that the position that $42,000 in transfers constituted undocumented personal loans that were legally valid, but also somehow still of undetermined status, was not one this proceeding found credible. He said the handwritten notations in the decedent's own records indicated that he had not understood the purpose of the transfers, which directly contradicted the claim that they had been agreed to. He said, "The petition to contest the will on grounds of undue influence is denied. The will as filed stands." He paused. "Additionally, I am referring the financial transfer documentation to the district attorney's office for review. That is outside the scope of this proceeding, but these records warrant a separate look." He struck the table once with his pen, not a gavel but the same intention. My brother did not stand. He sat with both hands flat on the table, staring ahead. His wife gathered her bag and walked out without looking at him. Their attorney spoke quietly into his ear for a moment, then also gathered his files and left. I sat still until the room cleared. My attorney was smiling the controlled professional smile of someone who is relieved and satisfied, but trained not to show it too widely. He said we'd done it. I said I knew. Outside, the afternoon had gone gray, the kind of flat overcast that makes the world feel like a photograph of itself. My brother was standing at the far end of the parking lot near his car, hands in his pockets. I walked toward my own car, and he turned when he heard my footsteps. He didn't say anything for a moment. Then he said, "You didn't have to go that far." I stopped. I looked at him. He looked older than I remembered, tired in a way that had settled into the skin around his eyes. I said, $42,000, Devin. 3 years of quarterly transfers. You coded them in amounts just under the threshold. You registered the LLC in her name so it wouldn't come up in a basic search. You knew what you were doing. He shook his head. He was struggling. I don't know if you ever understand someone else's pressure. Things have been hard. I said, you could have asked him. He would have helped you. He helped everyone who asked him honestly. His jaw tightened. He always helped you more. I said, that's not the same thing. He looked away. Across the lot, his wife was sitting in the passenger seat of his car, face forward. She had the posture of someone who had already started building the story she would tell about this later, and it wouldn't be a story about her. I said, you still have choices here. You can cooperate with the DA and make it easier. You can stop letting her make decisions for you. He didn't respond, and I didn't push. There are things you can't give someone that they aren't ready to take. I drove home the long way, past the house again. This time I stopped and parked. I sat in the car for a few minutes looking at the front porch, the swing moving slightly in the April wind. I thought about my father's handwriting in that folder, those small penciled question marks, the patience of a man who didn't know how to name what was being done to him but knew enough to keep a record. He had not been naive. He had been careful. He had been thorough in the way that careful people are thorough when they suspect but don't yet know. That was where I had gotten it from. The methodical attention, the instinct to document, the belief that if you looked long enough and carefully enough, the truth would organize itself into something undeniable. He had known me. He had trusted me not because I was his favorite, or because I had made him dependent on me, but because he had watched me my whole life and recognized what I was made of. That was not manipulation. That was 40 years of showing up honestly. I went inside and walked through the rooms slowly. The house was quiet and full of him in the way that objects are full of the people who lived among them long enough. His reading chair with the worn arm. The kitchen where he made coffee too strong and refused to apologize for it. The hallway where all the family photographs were hung without particular order, some crooked, some faded, a running record of the years. I took the folder with his annotated statements from the desk drawer and put it carefully in my bag, not because I needed it anymore for the case, but because it was his handwriting, and I wasn't ready to leave that behind. That evening I made a simple dinner and sat at the table with the paperwork spread out one last time. My attorney had already emailed to say the estate attorney would begin transfer proceedings within the week. The house, the property, the accounts, all of it moving formally into trust under my management, the way my father had intended. I thought about what to do with the commercial property. It was a small building on a corner lot, 2 storefronts, one currently vacant. My father had leased it to a dry cleaner for years, and before that to a woman who ran an alterations shop. He hadn't developed it into anything larger because he liked the scale of it, liked being the kind of landlord who knew his tenants by name. I thought about a nonprofit organization I had worked with briefly the year before, a group that provided financial literacy and legal navigation resources to women in probate and estate disputes. Exactly the kind of situation where someone without legal knowledge or financial background got overwhelmed and gave up what they were owed. They had been looking for a permanent space. The building could house a small office, a conference room, a place where someone could sit across from an advisor and be told plainly what their rights were and what the numbers actually said. I wrote a note to myself and set it beside the folder. The following month was quiet in the way that a long effort feels quiet after it ends. The criminal investigation into the transfers was opened. I was contacted once for a supplemental interview and provided additional documentation. My brother retained a separate attorney for that matter. His wife retained her own. I wasn't involved in how that went between them, and I didn't ask. Sophia had called once, early in the month, and said she was sorry. I said I heard you. I didn't say more than that. There are kinds of sorry that come too late to do the work they're supposed to do, and the right response to them isn't a performance of forgiveness, it's just acknowledgement. You were here, you said what you said, we both know what it cost. She asked if she could come to the house sometime. I said we'd talk about it. On a Saturday in late May, I drove to the commercial property with the estate attorney and the representative from the nonprofit. The building was brick, 2 stories, windows that needed washing. Inside it smelled like the dry cleaner that had operated there for 11 years. Good bones, as my father used to say about things that were worth the work required to maintain them. I watched the nonprofit's director walk through the rooms, checking ceiling height, noting the natural light, already thinking about layout. She had started the organization after her own mother had signed away an inherited property, because she hadn't understood the documents in front of her and couldn't afford an attorney to explain them. That specific kind of loss, the kind that comes from not knowing what you didn't know, was what she was trying to prevent for other people. My father would have liked her. He would have asked careful questions and then offered to let her use the loading dock entrance because it was easier than the front steps. I signed the lease agreement that afternoon. On the drive home, I stopped for coffee at a place I used to go with my father on Saturdays when I was a teenager. The counter was still the same laminate. They still had the same pie case with 3 kinds on rotation. I ordered a slice of apple and ate it at the counter and thought about nothing particular, just the weight of the day settling into something that felt, finally, like the right shape. The house was mine. His records were mine. The work we had done together, the ordinary accumulation of ordinary time, the kind that doesn't announce itself as significant until it's the only thing left, all of it mine to carry forward. I drove home in the early evening, windows down, the highway carrying that specific late spring smell of cut grass and coming rain. I had learned something in the months since my father died that I hadn't expected to learn. I had expected to learn about the legal process, about probate, about the specific mechanics of defending an estate from a bad faith challenge. I had learned those things. But the thing I hadn't expected was this: that the people who take from you, who build their strategies on the assumption that you are too tired or too close to see clearly, that you will eventually absorb the story they're telling about you and stop fighting those people, are not as careful as they think. They leave marks. They leave transfers with question marks beside them in a folder in a bottom drawer. They leave patterns that look familiar to someone who has spent years learning what they look like. They count on chaos to protect them, and what they don't plan for is someone who is trained to sit quietly in the middle of chaos and keep reading. My father had raised someone exactly like that. He had known what he was doing. He had written it down, in his careful hand, 1 question mark at a time, and waited. I had found it, I had read it, I had answered every single one.